First of all, thank you very much for your kind invitation to be part of this very interesting international project. I am very glad to be here. Especially, I would like to thank Professor Nora Jakab that I could write a chapter in your book. Moreover, my presence here is special for me for another reason as well. I am the coordinator of the cooperation between University of Silesia in Katowice and University of Miskolc. And in the name of University of Silesia, I am sending the warmest greetings to Dr. Gabromej Pataki, thanks to whom this cooperation started and developed. Thank you so much. However, to the edge, because I have a time limit, I will tell you only about a part of my chapter. I will tell you about the employment contract as the basis of the employment relationship, but I think it's the most interesting, I hope so, through the prism of different types of work. First of all, we should start with Polish Constitution. In Polish Constitution, we have some regulations about work. Work regulated under Polish Constitution has much broader sense than employment relationship under Polish Labor Code. According to Article 24 of the Polish Constitution, work of any kind is under the protection of the Republic of Poland, and the state exercises supervision over the conditions of work. Nowadays, in Poland, labor law is an independent branch of law, separate from civil law, separate from administrative law. Of course, there are strong correlations between labor law and social insurance law. However, social insurance law is separate from labor law as well. There are strong correlations with civil law. You have to know that in Poland, before Second World War, labor contract was regulated in the civil law. Labor law in Poland has its roots in civil law. Today, Article 600 of Labor Code is a key. According to this article, in cases not regulated by the provisions of labor law, the provisions of the civil code apply accordingly to an employment relationship, provided they are not contrary to the principles of labor law. After these introductory remarks, I'd like to tell you about the employment relationship. According to Article 22, Paragraph 1 of Polish Labor Code, by establishing an employment relationship, an employee undertakes to perform work of a specified type for the benefit of an employer and under his supervision. This is most important, under his supervision, in a place and the time specified by the employer undertakes to employ the employee in return for remuneration. The employment relationship in Poland is a central concept. It's the most important legal construction in the labor law. If we don't have employment relationship, if we don't have a subordinated work, we won't have an independent branch of law. The most characteristic for employment relationship are the necessity to perform work personally, employee subordination, as I said before, and remuneration for work. Of course, we can talk about employers' risks. If an employee performs work badly, the employer is the first to bear the consequences. The employer is sometimes obliged to tolerate the employee's absence from work. Employers have many social obligations. Moreover, the employer is also obliged to pay remuneration in case of disruptions in the functioning of the workplace. We know it very well because of the times of crisis, because COVID-19. Negative effects of economic events cannot, as a rule, be transferred to the employee. According to Article 2 of Polish Labor Code, an employee is a person employed on the basis of an employment contract, an appointment, an election, a nomination, or a cooperative employment contract. It is very important that we have enumerative list of basis of the employment relationship. There are no other bases of the employment relationship. The employment contract is the most common basis for the employment relationship. It is a bilateral legal action, consensual, bilaterally binding, and pecuniary. I would like to tell you something about functions of labor law. We have, in general, two functions of Polish labor law, protective function and organizational function. Of course, we know that employee is the weaker party of the employment relationship. The employer is a stronger party of this relationship. The employee is not able to safeguard his professional and social interests for his own. So this is why we need labor law, to protect employees under the regulation. The protective function manifests itself primarily in the principle of preference for the employee. I described it in my chapter, as well as in the general and special protection of the permanence of the employment relationship, the guarantee of remuneration, and annual leave. Polish labor law defines a minimum of rights and a maximum of obligations for the employee. The organizational function of the labor law helps employer. It defines rights of the employers and obligations of the employees. It is high time to say something about other types of work. As I said before, we have only 5 bases of the employment relationship. For example, mandate contract is not the basis of the employment relationship. It's a civil law contract. However, in Poland, we can the employment relationship as a legal relationship governed by the labor law has a specific legal character which distinguishes it, for example, from not only civil law relationship but also administrative law relationships and criminal law relationships. In administrative type of work, we have work relationships in which officers or soldiers performs service. Soldiers must follow orders. Yes, in the employment relationship, we have the possibility to give the employees instructions, binding instructions. In the administrative type of work, we have orders. In criminal type of work, we have work under conditions of compulsions and of compulsion. In the Supreme Court's view, the work doesn't have to be of an employee nature. According to Professor Krzysztof Baran from Jagiellonian University in Krakow, non-employment work includes all non-incidental provision of work except for classically conceived employment of a legal employee nature. And as I said before, persons who perform work under civil law contracts, for example, on the basis of a contract of mandate, are not employees. Such persons work outside an employment relationship. Moreover, it's very important, such persons do not have to be entrepreneurs. According to Article 22, Paragraph 1 of Polish Labor Code, Upper Index 1, work under the conditions specified in Article 22, Paragraph 1 is considered to work on the basis of an employment relationship regardless of the name of the contract concluded between the parties. Employment contracts cannot be replaced with a civil law contract where the conditions of the performance on work specified in Paragraph 1 remain intact. Moreover, in its judgment of the 7th of June 2017, the Polish Supreme Court emphasized that by the parties' will, the basis of work cannot be changed when the employee performs the activities specified in the contract, falls within the regime of Article 22. Sometimes we have very many difficulties with some contracts, with different types of work. I think that a good example is a graduate's internship contract. For sure, it's the best example. To be honest, in Poland we don't know what it is. No one knows. We have regulation, but we don't know what is nature of this contract. Someone says that it is a civil law contract, but graduate can perform work in subordination, can perform subordinated work. It's a big problem for us because of the definition of the employment relationship. So someone says that this is not a basis of the employment relationship, but it cannot be a labor law contract, not under civil law. The provisions of the Graduate Internship Act raise important questions, as I said. This contract is also very similar to an employment contract concluded with a young employee, with adolescents. There are very many similarities that, in fact, we don't know what we have. Is it an employee contract signed with adolescents, or maybe this is graduate's internship contract? Some other examples when we have difficulties in identifying the legal nature of some contracts. Self-employment. My colleague from Slovenia, for example, told us about it. But in Poland we don't have regulation of some self-employment, unfortunately. We have very old labor code. There were tries to have a new labor code, but unfortunately we still have our old, from 70s, labor code. Cottage industry, another example. Because of COVID-19, we have regulation about remote work. And in fact, we don't know what we have in some example. If it is a cottage industry, or maybe it is remote work, because remote work has much broader sense than telework in Poland. Management contract, for example, a contract concluded with the president of a company and work through online platforms. I saw that Gabor Pataki will tell us about this type of work. So it's everything from me. Thank you very much for your attention. I will like to discuss with you during roundtable about graduates' internship contracts, if you would like.
It's also clear from the previous presentation how much the Hungarian and Polish labor law regulations have in common. Several parallels can be drawn between the two regulations. The background to this, of course, is partly the common historical roots and partly the membership of the European Union. The basis of the Hungarian regulation is the constitution, according to which everyone in Hungary has the right to freely choose their job and occupation. There is also state control over work through the employment and health and safety authorities. Starting from the constitution, an independent labor code regulates employment, which contains comprehensive and complex legal provisions. The Hungarian labor law regulation fixes the score system of labor law through paragraph 13, the labor code. It's also very similar that people in public services are employed under separate legislation. The two closely related public service legal relations arising from employment are also based on civil law, and one of the most important principles in the principle of freedom of contract, which is also guaranteed by Hungarian legislation. Based on the principle of freedom of contract, parties are basically free to determine the content of the employment contracts, and paragraph 45 of the labor code essentially defines the content. The current Hungarian labor law legislation is very close to the general principles of civil law. It gives the parties a wide margin to freely shape the content of the employment relationship through the contract, with the condition of obligatory to conclude a collective agreement being set relatively low in the labor code, as 10% representativeness authorizes the trade union to enter into a collective agreement. The Hungarian regulations based on the nullity can be invoked by the interested party without a time limit. The nullity of the agreement will be established ex officio by the court. Consequently, if the employee justifies a ground for nullity, the court may even declare the collective agreement null and void. Of course, as in Polish solution, there is a close link between the rules of the collective agreement and individual employment law and the employment contract, as the so-called normative part of the collective agreement can define the rights and obligations of the employee. Furthermore, as a Polish law, a collective agreement applies to all employees, regardless of whether they are members of the trade union which concluded the agreement in question. This, of course, arises dogmatic questions, as it authorizes the trade union to conclude the collective agreement, and the additional question arises as to whether if the collective agreement is concluded during the employee's employment and fundamentally rewrites the employment relationship and questions the opportunity for the employee to take action against the collective agreement in any way. I'm even thinking here of calling for invalidity as a title. In Hungary, the main direction of dogmatic research is related to the contract and the contract as an independent legal institution, and the scope of problems outlined above can be well included in this circle. In many respects, the epidemic of the last 2 years also means rethinking labor law rules and ensuring the possibility of working from home and defining their legal frameworks has become a priority in many sectors. Thank you very much.